So welcome everyone and welcome Jason to the Let's Talk Privacy and Technology series. As you know, we bring on guests, privacy experts in the intersection of privacy and technology. We've had privacy engineers, privacy tech founders before, academics who write about privacy and technology, and today is no different. As you know, I'm Lourdes Turrecha, your host. I'm the privacy tech and law fellow at Santa Clara University Law School, where I'm also an adjunct professor. Today we have Jason Cronk, who is the author of Strategic Privacy by Design and the CEO of Enter Privacy Consulting. Welcome, Jason, and thank you for your time today.
Hey, no problem. Thanks for having me on. I'm excited to be here. I certainly am in good company with the previous guests you've had.
Yes, we're really excited that we've had great guests, with Michelle Dennedy and Lori Craner and Professor Hartzog and the founders who have been building tools in privacy that we've come to know and chatted about their startups. So thank you. I want to kick us off where I usually do, which is, by asking you to walk us through how you got to where you are working in privacy, particularly as it applies to tech. And we've had discussions about what do you mean by this. So the broad umbrella of this series is to look at the intersection of privacy and technology, not just privacy tech, the landscape of tools building for privacy, but really the broad intersection of privacy and technology. So privacy as it applies to the tools that we use today and to companies that are building technology tools. I know you've been an author, you have your own consulting firm, you've built really interesting rules that like the model privacy notice generator. And so I'd love for you to share with us how you got to where you are today, particularly share about the non-legal roles that you've had. I know you're a lawyer, but you have also chosen non-legal roles, or at Santa Clara, we like to call them JD Advantage roles. And maybe walk us through the reasoning you had for the choices you made in your career.
JD Advantage. I don't know. JD Disadvantage might be another term. So yeah, it's interesting. I've tried to not take up the entire time going through my background. We'll start out. I started out back in technology and IT long time ago. My undergraduate degree was in mathematics with a minor in information systems management. I was always into computer programming. Came out of college, started a business, could have been the CEO of Redbox. It was a CD vending kiosk, but I was way before my time. I mean, literally, this was in '95. DVDs had just come out, and we built this CD vending kiosk where you could sample music. Okay, side trip. Started my own web hosting and web design company along with some friends.
I didn't know that. Interesting.
Ran that for a couple of years, did web development, programming, mostly back-end stuff. Then went to work for my aunt, and we formed a company. We started out because I built a website for her. We still have that, but I'm not really actively involved. That's more her and my cousin. Then went to Verizon and worked in their information security department, again, as a developer, but as a security conscious developer. What's interesting is during this time, going back to earlier, right after college, my roommate was a private investigator and repo agent. And so he used to tell me all of the fun stories of how they would socially engineer and get people's information, and the rudimentary now in these days, but seemingly sophisticated information that you could get from data brokers back in the day when they were trying to skip trace people, led me to, ever since that, for 20 years, I've used primarily a mailbox set, like a Mailboxes, et cetera, or UPS store. Because again, mailing address and knowing where you live is often synonymous for most people. Anyway, so that got me into privacy, knowing about the risks from people like my roommate. So I went into information security. I saw that everybody in privacy back then was a lawyer. So I was like, well, maybe I need to go to law school. So I ended up going to law school. with the intent of becoming a privacy lawyer. Either that or eminent domain. I had a kind of an interesting interest in eminent domain at the time, but primarily a privacy lawyer. Unfortunately, this was later in life. I came out in 2009 at the bottom of the legal market. I had a colleague. For 9 months, she was a pizza delivery driver as a licensed attorney. Luckily, I was able to fall back on my position at Verizon, called my old boss back after applying for 100 legal jobs and not getting any callbacks because I had no experience. And she brought me back in a technology role. Was there for a couple of years, but there was a reason I left this place. I was not interested in doing the development work and being there for another 20 years. And so eventually embarked out on my own, doing privacy consulting. Learned that consulting is a lot more about marketing than it is doing the actual fun stuff of helping clients. Got frustrated after a while, ended up landing a job. And this kind of plays into, I guess, the JD advantage. I worked in the information security department at NCR, but I interfaced with the lawyers and I interfaced with vendors and clients doing contract negotiations. So a lot of it was reading through contracts and saying, knowing the technology, is this what we're actually doing? Can we actually do what they're asking? Making sure the vendors are doing what we need them to do, from mostly an information security, but also from a privacy aspect. So was doing that, started doing a little bit more and trying to help the organization with, this is where I got really into the privacy by design aspects. Unfortunately, that organization wasn't able to fully utilize my talent in that area. So I eventually went part-time with them, focusing on privacy by design, mostly training, started branching out to other customers, clients, and building on from there, and have built a moderately successful consulting and training company as a result. Before the pandemic, I was doing training all over the world, traveling. That was the fun aspects that you referenced before we started recording here. Unfortunately, with the pandemic, I mentioned, so I went to law school. The house I have is in Tallahassee, Florida. After I was in law school, I couldn't sell the house because it was the mortgage market, or the real estate market, had collapsed. So I ended up turning into a rental property. Well, happenstance as it was, right before the pandemic, back in November, the tenant skipped out. So I put the place on the market, but I needed a place to live. So I ended up coming down here to Tallahassee to kind of escape and isolate myself. So no longer leading the exciting lifestyle, but still working hard at privacy. So just a little bit of a further extension of that. Like I said, I've always been a developer. So when it came time to do in some of the aspects that I've looked at in privacy by design and privacy risk analysis, and you mentioned the privacy notice tool. That was originally a collaboration with Dan Solov and myself, and I did the programming side of it. Even though I wasn't really a programmer anymore, I still knew enough with JavaScript to get by. I did recently, or in the last couple of years, I created an Excel calculator for doing privacy risk analysis under using a modification of FAIR, factors analysis and information risk. And that is part of the privacy engineering collaboration space with NIST. Now I submitted it there, worked on a JavaScript-based tool. And now, luckily, I've been able to hire a couple of people part-time, a program or a product manager and product developer, and then project-wise, a product designer. And we're working on getting that risk tool, a privacy by design wizard, up. And then hopefully, if we can get to it, is expanding that privacy notice generator. So that's where I am now.
That's really cool. There are three things that I want to touch upon. First one is your role in InfoSec, and you seem to be way ahead of your time. That's a development that I've been seeing with either lawyers needing to learn InfoSec or GRC/InfoSec professionals needing to learn the legal requirements for vendors. And I've seen that play out in several organizations, including ones that I've worked with or were clients of mine. And it just goes to show the intersection between privacy and security, but also the cross-functional nature of the space that we work in, right? Like it really doesn't matter as long as you're interested. It doesn't matter where you come from, but if you're interested in all of these different areas, you know, may you have a legal degree or an engineering degree or an InfoSec background. If you're interested enough, I've seen it play out where people are able to crack into this and break into this field with that interest, curiosity.
Lots to unpack in your statement there. First off, let me address the multiple disciplinary activity of privacy. And this is one of the things that I think my background has been helpful. Obviously, the tech background and the legal knowledge has been helpful, but also my curiosity around, like, for instance, I mean, back when I was in college, I took courses in game theory, and it wasn't called behavioral economics back then, but it was essentially, you know, about, you know, behavioral economics. I've always been fascinated by that, and that has implications in cognitive bias, which implicates privacy, you know, psychology. Again, these are more personal interests, but having all this diversified interest really plays into being a good privacy professional and not siloed in the law or technology or, you know, one narrow aspect. So I think, and going along with that, one of the things I did early on, and not by conscious design, again, just kind of by interest, is I attended academic conferences. I attended legal conferences like Privacy Law Scholars, you know, Dan's conference, that. I attended technology conferences, and I attended professional conferences, so like the IAPP stuff. So by having this diverse view, because it's really actually fairly siloed. I don't see the same people at these conferences for the most part, right? Exactly. There's not a lot of crossover. So when I'm at an IAPP event and I start talking about this academic stuff, people think I'm a genius when I only know like this much of, you know, because I attended 50 talks on differential privacy and it kind of sunk in. I couldn't do it if you know, put a gun to my head, but I can talk about it intelligently with somebody who knows less than me. But if I talk to somebody who knows more than me, you know, I'm sunk. But I at least have enough. So what's the phrase? I know enough to be dangerous. So I know enough of these topics that I can talk intelligently across multiple fields, you know, but not necessarily, you know, engage. And again, I did a talk, a rump session at Financial Cryptography Conference, and I offered up the crowd 2 potential talks I could talk about. This was about Bitcoin years ago. And I said, do you want me to talk about the legal aspect or a technological flaw that I think is there? And they were like, legal, because there was nobody else talking about the law there. So I was able to opine about something, you know, on the law side that was novel for that crowd. Whereas if I had talked about the technology, you know, there's a ton of people talking about the tech, and I probably wouldn't have come across as intelligent as I did talking about the aspect that they didn't know. So, okay, so that goes to the diversity. I can't remember, what was the other part of your statement, or you asked a question about bringing in, letting InfoSec people know about like the law, or lawyers knowing about InfoSec.
I've also seen it where I've had really amazing colleagues whose backgrounds are from InfoSec, GRC type of roles. They're not lawyers, but they've learned enough about, you know, the requirements of GDPR, for instance, so that when they do their vendor risk assessment, they can help issue spot when it comes to their vendor review. So I've seen it where lawyers try to learn the InfoSec space and the different domains and what standards and frameworks they should be looking out for in contracts. I've also seen it the other way around, where I've seen InfoSec professionals learn the legal requirements that they should be looking out for when it
Yeah.
comes to vetting vendors.
So I'd say both of the fields have their own jargon. And the problem is, if you're in another field and you're not familiar with that jargon, it makes communication difficult. I would suspect that it's probably easier for, now I want to caveat this, I was going to say probably easier for an attorney to know InfoSec than vice versa, because the law seems to be more nuanced in a lot of places. That being said, I'm not suggesting that lawyers who don't know InfoSec can learn InfoSec any better than an InfoSec person can learn the law. What I'm suggesting is a lawyer who has a prior technological background, and not necessarily from my case, I'm saying, as new lawyers and younger lawyers come up who have grown up familiar with the technology, they're going to make better lawyers because they can speak intelligently on what they're saying. I mean, this goes back. I remember a day when I was in my 20s, and I had a lawyer doing something for me, and he was still dictating. He didn't know how to type. He had never learned how to type. He had a computer, but because he had always dictated his messages for his assistant to type out. And when I was in 7th grade, I took typing classes, and because I had an Apple II computer, and I was the only male in that class because I wanted to learn how to type on my computer. I didn't want to be a secretary, but I wanted to, and it just fascinates me that, people back in those days grew up and without the expectation of learning how to type, and therefore they end up doing like this. So.
I love the point that you're trying to make with, lawyers who are interested in privacy or anything technical, practice in technology. Just, I think the idea is to be curious and to self-teach, right? Right. So that was my.
You can't force it, right?
Right.
If you're curious, I mean, this is why kids learn, right? Because they're curious. Not because they sit down with a learning lesson and learn. It's because, what does this do? What does this do? And they start banging on things until they break something, and then they go back and repeat. And as long as you stay curious and youthful, you're going to continue to learn and learn new things.
Yeah, no, absolutely. And that was true for me as well. My first job was within the CISO's organization, building privacy from within InfoSec, not within legal. So I've seen both, ways they could play out, and in order to do that, you really have to be curious and interested in InfoSec, in that domain and how it affects privacy. And but yeah, so that's pretty much a takeaway I wanted to drive home for not just the students that we have at Santa Clara, but for those who are interested in breaking into privacy, which is becoming more and more technical. I would love for us to jump to the model privacy notice generator and talk a little bit about what led you and Dan to build that. I understand that there was an ONC, and maybe you can just flesh it out for us further, and what people can use the tool for, what's the scope of the tool, how it works.
Yeah, so this was a couple of years ago. Right. Time flies. Wow. So 3-4 years ago, 3.5 years ago, something like that. The HHS, Department of Health and Human Services, office, the ONC, I can't remember what office of something. Anyway, they put out a contest for somebody to create a privacy notice generator for health applications. So apps on your phone, because they weren't subject to HIPAA. So they found all these health apps coming out there collecting health data, but not really doing anything appropriate with it. I saw it and was like, oh, that's kind of curious, but I really kind of dismissed it. And then Dan emailed me because he knew I was a little bit more technical than he was. Again, no superstar programmer, but I can at least program some JavaScript. and had a background in programming. And he said, "Hey, can you want to work on this together?" And I was like, at first I was a little hesitant, and then I was like, "Okay, yeah, we can do this." Then I really got into it, and I'll tell you. So we ended up winning. We won $20,000, which Dan and I split. And what was really absolutely important for winning that, I think, was because both of us were lawyers, we were able to follow the rules to a T.
Got it.
They asked for numerous things. They said, do this, do this, do this. We went through, did this, did this, did this. So one of them, for example, was doing a user survey. So getting feedback from your users, integrating that feedback, and then getting more feedback. I was in Toastmasters at the time. I went through and I gave all my Toastmasters participants a $5 either Starbucks or Dunkin' Donut gift card to participate and give me feedback about the privacy notice. And I incorporated that, and I incorporated the changes that they, or the pain points that they had. And in our presentation or in our submission, we showed that. Most of the others.
Let me follow up. Did you give them the tool to try out, or you gave them a notice to read that was generated from the tool?
A notice.
Okay, but
the notice that was generated, yes.
Got it. So did they have
as a consumer, yeah.
They had to generate it themselves, or you did it?
No. I generated a notice, and then they reviewed it and gave me feedback.
But just to be clear for the attendees, what you built was a generator, was a tool where an app developer could go on your website where it's
a bunch of questions,
right,
and it would generate a privacy notice for them. A very simple, like so again, one of the other things was, is the language simple enough for the average consumer? Well, the average American reads at a 10th grade reading level. So we looked at the Fleischmann-Kincaid scale of readability and made sure that we were like 8th grade or below.
Wow.
All the words were very, so again, we did all these points. The other competitors that I looked at, they were like, oh, I asked a couple of friends to look at it, and they said, they gave me this feedback. We had 20 people, and here's what they rated this, and here's where their pain point was. I mean, again, I'm no expert in that area, but I knew I researched enough about doing usability studies to be able to, present something that looked reasonably professional.
Right.
And again, I think that was what was key to our winning, is we checked off all of the boxes because we read through the requirements multiple times, and our lawyer skills, played into, oh, they've got a comma here. That means, again, I'm exaggerating, but that's the kind of level of detail, whereas I'm sure a lot of the participants just kind of read through. It's like, oh, build a privacy notice generator. And they, built something and didn't really go back and forth. Here's what we built, and here's what it. So I asked Dan afterwards, I said, oh, this is great. We won. Let's see if we can take this and make this a business or a product. Dan was not interested, and frankly, he was probably right in that it was a limited business opportunity, and neither of us are big fans of transparency and notice as a privacy tool. We think it has limitations. I mean, Dan had a whole article on it, and I certainly I don't dismiss it, but I've been dismissive of it for a long time. That being said, there is still a desire and a need in many cases to generate some kind of privacy notice. So I modified what we had done for HHS to comport to the GDPR requirements under Article 13 and 14 for transparency, and also Article 11, which is about which goes to the ease of use, making sure it's accessible, those sorts of things. And I put it out there. We had, a few initial buyers, but over the years, it's been, to be honest, of limited success. And I think, so there's a couple of reasons to that. One is it's competing with free. So what most people do, or most developers, is they will cut and paste a privacy notice from somewhere else and just stick it on their website. And so I'll try to be as generic as possible, but I was at a client that had a service that provided white labeled websites. Okay, and these white labeled websites, so you're some kind of e-commerce related site. These white labeled websites, the client wanted a privacy notice to go on the website. So even though the chief privacy officer was against it, the business wanted to provide a template for a privacy notice, even though, again, they were worried about, like, are we providing legal advice by giving them this template? Regardless, they provided a template. I remember going on and looking at a lot of these clients, and they would have the template unaltered. In fact, unaltered to the point that it would say, insert name of company here, insert address for contact here. They wouldn't change it at all, and just, it was kind of like, this is useless. But the point is, people just don't care. So like I said, I have this product manager and developer. Once we get through my risk tool or at least an MVP of my,
I actually want to talk about the risk tool and pivot to that and talk to us about who is the intended user for the risk tool.
Well, I'm gonna turn it around and ask you a question, but I just want to finish on that. So we are looking to hopefully expand the privacy notice into, like, doing a WordPress plugin that people could use. And there's all sorts, like Shopify plugin. I mean, all sorts of plugins that we could potentially do. And also go after, and this comes down to marketing, which I'm horrible at, but go after the app market. So again, those initial developers, because now, like Apple and Google, require apps to have privacy notices, and a lot of apps don't even have websites. So the question is, can we really charge them for the hosting? Not much, $5 a year, $10 a year. But if we can get 10,000, 100,000 apps that are paying $5 a year to host a privacy notice that they click through and ask some questions, there may be a market opportunity there. So,
are you looking into the Apple information, privacy information / quote unquote nutrition labels, and incorporating that into the tool?
Sure. So again, we're going to look at that once we get to that stage of what that market is. I'm really reticent to put in a lot of work effort into it because again, I'm concerned about whether there's a market there, and whether the market is really about marketing and bringing in customers. I think we talked about this when you had Melanie and yeah, on your other event. And marketing is a perennial problem for any company, but certainly in the privacy space as well. So if any of your audience can crack that nut, let me know what that is. Okay, privacy risk tool. So like I said, I did an Excel calculator that is available at the NIST Privacy Engineering Collaboration space. I actually have a new version that I will be uploading at some point. So,
and just to stop you, it's a calculator for privacy risks, correct?
Yes.
Okay. And maybe
and I'll unpack that in a second, but so Stuart Shapiro and I have written a paper on quantifying privacy risk using FAIR, factors, analysis, and information risk. Now, this is something I had done in my book. There was a chapter on my book on this, but we kind of wrote a more academic and paper with a little bit more scrutiny, and we've submitted it to a conference. And we'll see if it doesn't get there. We may submit it to there's a few others we'd like to try. Once that paper gets accepted somewhere and or published, then I will probably update the Excel spreadsheet with the privacy engineering collaboration space. The point here is to do quantification of privacy risk. Now, a lot of people are used to quality-based risk assessments, a high, medium, and low. The problem is everything turns out to be medium. And when you're prioritizing 50 things that are medium, well, which medium is more important here? So it gets difficult to kind of prioritize that way.
How did you
So,
decide how did you decide how to assign? Did you look at external models and how to assign the numbers for different levels of risk? You said instead of low, medium, high, there's what, 1 to 5 or 1 to 10? What is it?
none of that.
Oh, okay.
So that is what we would refer to as faux quantification.
Yeah.
So you're assigning numbers, but they're kind of arbitrary.
Right.
How deep down the rabbit hole do you want to go? So FAIR uses privacy risk factors, for instance, opportunity. Okay, so you have a threat actor and you have an at-risk individual. So how much opportunity, how many opportunities in a year does that threat actor have to interact with that person? Okay, so let's say, for instance, I'm trying to think of kind of a simple, okay, let's say, I leave my blinds open and I'm wandering around my house en natural, right? So a person walking by my house could see in, right, and potentially see me. Now, how often does that person walk by my house? It's different if we're talking about my neighbor who has a persistent opportunity, every time I walk around, or somebody who just happens to be passing by. Well, I'm not on a very busy street or medium busy street, but it would be different if I was, down some alcove somewhere and didn't really have a lot of foot traffic. So again, determining how many opportunities for this potential privacy threat are. So that's the first factor. So again, it's not a faux quantification. It's actually like, oh, that's 50 times a year, 500 times a year, 50,000 times a year. Let me pose one to you this. Now some of it is technological constraints, right? So let's say you're a spammer and you're going to spam me. How many opportunities a year do you have to spam me?
Countless.
Okay, you would think it's infinite. It's not quite infinite because it's limited by technology, right? So as fast as your server can send messages and as fast as the internet pipe between us can send messages. So it is huge.
Which is what is that number now, if it based on?
It's huge, but it's not infinite, right? Now the next factor, and again, I'm not going to go through every single factor. The next factor is motivation. How motivated are you to the threat actor to commit this this threat? And we do that on a percentage scale. 100%, like every opportunity you get, you're going to send me a spam message, or 0%, you're never going to send me a spam message. Well, I have some retailers, legitimate retailers that will send me, until I unsubscribe, will send me 3 messages a day, right? So we can determine the attempt frequency, which is a combination of these factors, is essentially 3 messages a day. So that's 1,000 messages a year, right? So that's 1,000 attempts a year to send me spam. Now, you also have to think about diminishing returns. The more you crank up that spam, especially if there's an unsubscribe feature, there's going to be a reaction on my part to unsubscribe. So there's a diminishing return. Anyway, point being, as you can see, this isn't like, oh, it's 1, 2, 3, 4, 5. This is trying to use empirical information or subject matter expertise to interpret information to come up with a frequency. How often does this happen to the population? Impact. Go ahead, sorry.
Who's going out and getting that empirical information? Is it the user? Is it a third party, expert? How is that? So there's that thing. What ends up happening is that the user ends up doing the faux quantitative assignment, right? Because they're the ones using it. For this tool, are the numbers coming from somewhere else? Where is it coming from?
So excellent question. So it's really, it's up to the person who is going to be using the tool
Yeah.
to either go gather that information themselves, or like I said, Jack Jones, who was one of the creators of FAIR, Factors, Analysis, and Information Risk, uses the concept of, now I'm trying to remember, I want to go back to quantitative easing, but that's an economic term. It's some kind of estimation. And now, for whatever reason, I'm drawing a blank. But basically, okay. So I know this is a little difficult because I'm sitting. You can't really see my height, but we've met in person. How tall am I?
I don't remember, to be honest.
Okay. So am I between 3 feet and 7 feet tall?
Of course.
Would you be willing to bet $1,000 on that?
Yes.
Okay. Am I between 4 feet and 6 feet?
Yes.
Would you bet $1,000 on it?
Yes. Did I just?
Okay. Am I between 5 feet and 5.5 feet?
I don't know. Maybe.
Okay. Would you be willing to bet $10 on it? Okay. You see, you see, we can get this down. The range is down.
Got
So
it.
there's some things that are like ridiculous, and there's some things that we can get. We maybe don't know, but we can estimate, and with some level of confidence, basically a willingness to bet $1,000 or something on it. So that's how you go through and kind of, if you don't have empirical numbers, you can kind of make reasonable estimates. And so one of the things about risk, and this is where a lot of the qualitative models don't provide, is there is some uncertainty. Well, there's two parts. There's uncertainty and there's variability. Not every threat actor, like I said, we have variability. We have the neighbor across the street. We have the person who walks to work every day. And we have the interloper who just happens to be walking through my neighborhood. So there's variability among the threat actors, and there's uncertainty. I don't know, is that person walking to work every day? Are they doing it twice a day because they're going back and forth? Are they only going to work this way and they're coming back the other way? Are they coming at hours that I'm actually in my house or I'm away? So there's uncertainty. So this helps describe. So what you do, so I'll just say this calculator then runs simulations, and these are called Monte Carlo simulations. So it basically takes a potential value for opportunity, a potential value for motivation, a potential value for threat actor capability, a potential value, and it combines that and says, here's one potential privacy risk value. Oh, let's do another one. Let's do another one. Let's do thousands of simulations. So let me see. It looks horrible, but let me just see if I can. I don't want to take the time. I was going to show you behind me, although it blanks me out.
So is the simulation part of what you provide in the tool, or is it another third-party aspect to it?
I'm sorry, say that again. You're
talking about some of the simulations bringing in. Okay, I see you now. You're sharing your.
So this is again a bunch of simulations. The red is risk simulation. Right. The farther it is to that side, that is more risky, and the less is this. And then the blue area is tolerance. So that's your acceptable level of risk. And this is for this particular class. So this allows you to check your tolerance against, and how do I turn this off?